Welcome LPC members to our September LPC meeting. Thank you all for being here, and thanks for those that are joining online. It was great to see so many of you at the League's annual conference. Just what feels like a short 10-ish days ago. Our first order of business is to approve the minutes from our August 19th meeting. Can I get a motion to approve those minutes? Oh, I see one from Mayor Burton. Do we have a second? Stan Dugan. Great. All in favor, please say aye. Any opposed? Awesome. Our minutes are approved. First on our agenda, we are going to turn time over to Justin Lee. He is going to discuss Title 20 and PAPEA, the statute we have all now become much more familiar with. Justin.
So excited. I'm looking up really quick to see if I can find the court case. All right, good morning, everyone. So just quick update. First off, thanks for everyone who joined the webinar last week when we talked about PAPEA. There were a lot of great questions. Have had other cities and folks reach out to us with questions. So as a reminder, not going to hash into this one, but don't spend public funds on political purposes unless you're supposed to. That's a quick take. Don't do it unless the law tells you to. The reminder or update, I guess, if you have not yet heard, is we've spent some time also talking about Amendment D. There was the court case last week. The judge heard the arguments for against Amendment D. The judge ruled that Amendment D is void. So as of right now, Amendment D will not have votes counted for it, but it will continue to be printed on the ballot. A couple of reasons there. One, that allows time for the election officials to get the ballots printed and out correctly. Also allows time for the appeal that is going to take place. So the legislature has appealed to the Utah Supreme Court over the judge's ruling about Amendment D being void. The Supreme Court is going to hear that, and so we should have a ruling sometime the next week, 2 weeks. We'll find out whether they're going to uphold the lower court or whether or not that will go back on the ballot, or I should say have votes counted on the ballot. So what does that mean for PAPEA? Right now, Constitutional Amendment D is not a ballot proposition. It has been voided by a judge. So technically not a ballot proposition right now. That being said, it is, again, going to the Supreme Court, and there could be a hearing. There is a possibility that Supreme Court comes back and says, no, this is on the ballot. So right now, technically, PAPEA doesn't apply to Amendment D because it is not a ballot proposition. It could come back and be a ballot proposition, and it would then apply again at that point. So just want to give you that fun mental update. We'll keep you updated in Friday Faction and other places about where that's going. But just some exciting, if you're a political geek, this is just some fun, exciting back and forth. If you're looking forward to the legislative session, this is going to be interesting to see how people feel about it. So just want to give that update to anybody. Any questions or comments? So the question is, yes, I'm going to address this, Mayor Burton. It was that good. If Amendment D means dead, if it comes back as an Amendment B, and the answer is no, it's already been taken. So they could give it a different number, a different letter that was R for resurrected or something. I don't know. But we'll see if that one, again, we'll see what the Supreme Court comes back with, but there will be the hearing on that one next week. With that, I'm going to turn the time over to Molly to talk about homelessness.
Hi, everyone. Also, I just want to point out the beauty of Molly on homelessness as opposed to every other normal agenda item. I feel like I'm like in a jam band or something. We just wanted to give a few updates on the State Homeless Board. That was created this year, and we have Mayor Stevenson and Mayor Mendenhall as our local representatives on that board. We just wanted to point out that a lot of the policy within homelessness is moving through this board, and a lot of conversations are happening that we wanted to put on your radar. A lot of the board members are, all right. A lot of the board members are relatively new in this policy space. And so there is a lot of opportunity to make sure we are bolstering understanding of what role cities play in the homelessness system, as in land use and public safety, what cities have done so far to contribute as far as hosting, mitigation, all the winter response plans that people have been putting together, etc. We've been getting a lot of conversation in these board meetings that we've been listening in on why is the state doing so much? Why aren't cities and counties doing more? Shouldn't this be a city or county obligation? And so we just really need to make sure that we are working to educate this board on what our role is and how we can step up and rise to the occasion as cities, but also that cities do have a limited role when it comes to homelessness response. Policy-wise, we also wanted to put on your radar that they are revisiting the best way to provide services specifically within Salt Lake County, but this may have ramifications throughout the state. Specifically, they're discussing whether we should keep kind of the scattered site model that has locations within Salt Lake County and Salt Lake, South Salt Lake, Midvale, a temporary facility in West Valley, and Sandy, or if it is time to move back to campus model. And I bring this up because a campus model would have really seismic changes and impacts on the local policies that we've created with the mitigation fund and other ways that cities are kind of all participating within this process. So we wanted to make you aware that these conversations are happening. In the most recent board meeting, they also allocated their tentative funding for their winter response plans, recognizing that not all counties were in compliance, but trying to give themselves enough buffers that those that did have compliant plans could be operable, while still saving some funding for other counties to come online. Are there any questions? All right, thank you.
All right. Thank you, everybody. We're going to talk through some of our recent research, specifically spending some time on justice courts. And then we will mention a few other research asks before we dive deeper into probably the meat of today's meeting, which is land use task force and Commission on Housing Affordability feedback. So this justice court survey, just by a quick show of hands, how many of you saw this in Friday Facts or filled it out? Okay, see a couple. Awesome. So the background on this was a pretty short survey. We worked with Matt Dixon, who I thought I saw earlier, but I don't see anymore. Matt Dixon's our appointment on the Justice Court Reform Task Force. This is a state task force that was created 2 or 3 years ago to try to figure out what, if anything, we need to change with justice courts. And Matt worked with us to put together a quick survey to try to get a broader sense of municipal perspectives on how justice courts are operating, what, if anything, needs to change, and concerns about some possible changes. And I'll say we had about 112 total responses, mostly from 5th class, 3rd class, and 4th class cities, which is the majority of our members numerically. And that provided a lot of really interesting insights. I'll say, before I get into the kind of the results, this is all preliminary, but I would say I was kind of surprised because anecdotally, we've heard a lot of frustrations about justice courts from local governments, specifically around the cost to administer, staffing challenges, and then there's some other legal mechanisms like concerns with de novo appeals. But I was pretty surprised. We asked a couple questions on like specific mechanical changes. So the first one was how people felt about moving Class B and C misdemeanors out of justice courts to a new system. The new system was not defined. I think a lot of respondents read that as moving that to to district court. But what we found was a pretty strong majority, 63% of respondents were opposed or very opposed to this mechanism. And there, we asked for text responses, and there was a wide range of opinions on this, but many of those seemed to be concerned about losing access to justice. There were concerns about the financial viability of justice courts after you move many of those out because you wouldn't have the same revenue. And then there were also practical concerns about, you know, if you have people trying to get to hearings, but they're in another jurisdiction or they're in another county. So Yeah, this was really interesting and insightful. Another one, we asked about moving small claims cases out of justice courts to a new system. There's less concern there, but still the vast majority of folks were opposed to that. Again, this is kind of similar reasons that a lot of respondents felt like justice courts couldn't arbitrate small claims cases pretty efficiently, and they didn't want to clog up the other systems. There's also concerns about the cost of standing up a new system to deal with small claims cases specifically. And then lastly, we asked about 3 different kind of approaches. So those were more specific mechanically, and then 3 different approaches. The first being how people felt, and this was on level of interest, about closing their justice courts regardless of possible reforms. You can see the dark green is very interested. The lighter green is interested, yellow is uncertain, orange is uninterested, and red is very uninterested. So again, a little bit of a different take, but the vast majority of respondents were not interested at all in closing their justice court regardless of outcomes. They wanted to keep them. Some even saying despite the cost, they felt like it was a valuable resource to their constituents. There were several who said, yes, absolutely, we want to get rid of our justice courts because they're not providing the residents the services they need, and they're being subsidized from general funds or other revenues. We asked about interest in justice courts remaining as is, both some consolidation. I think this was a pretty interesting response where you saw some more interest there. And this might be sort of a middle ground approach the task force can look at, because there are some communities who said our justice courts are already, they're already overpacked with cases. We don't have room to consolidate without increasing delays or creating more challenges for people to access justice. But quite a few said, we only have our justice court open 1 day a week. The next jurisdiction over also only has theirs open 1 day a week. If we could just share, basically have it at one site, share justice, we think we could do things more efficiently. So there's kind of a blend here. And I think that it speaks to the uniqueness of different justice courts, and there's not a general consensus with how people feel about their justice courts or the justice court system generally. The last one we asked was just keeping justice courts they are the way now. Most respondents like that approach. And I'll mention that there's a blend of elected officials and staff. Administrative staffers tended to be more interested in closing the justice courts or reforming them, I think largely out of concern either about the de novo appeals or just from a cost standpoint. The cost of operations was interesting as well, because larger communities said we're subsidizing these heavily out of our general fund. Mid-sized communities seem to say we're at a break-even point. And then quite a few said they, mostly small towns and rural counties, felt like justice courts were actually a net source of revenue for their community. And so they wanted to keep it for the revenue for their jurisdiction and the job. So kind of a wide variety of opinions on them, both administratively and these approaches. The next steps will be working with Matt Dixon to share these results with the Justice Reform Task Force. We'll be meeting with somebody in the AOC, I think, to talk through these and these findings. But I just wanted to kind of give you a chance to respond. If there's anything we missed, again, there's 110 something responses. So this is a pretty quick summary of those, but I'd welcome any feedback as to what we found. If these are totally different than what your experience with justice courts, we'd love to hear it. Basically, we just want to get as much feedback as we can before we put something into a final report for the state. Yeah.
Yes. Lynn Pace, Sandy City. Carson, can you remind us, it seems like you had said there with this justice court reform task force, it seemed like there was something on the agenda to decide this session and other things that they were just going to continue to study. Is that correct? Can refresh us what's on the table now versus what's a continuing study item?
Yeah, I will do my best. I don't know if Matt's here. Matt's not here. And I'll say I've not actually been as involved in that group, so I don't know what they're looking at exactly. My understanding is, did you have something, Justin? Oh. Gotcha. Yeah, I'll have Roger answer that instead of trying to flounder my way through it.
Since Matt's not here, I've been sort of drafted to be an ad hoc participant in some of this. I don't think there's going to be anything done this session. I think they're going to continue on with their study. I think the challenge here is that anything you do costs money, and the question is arriving at what that is. This has only been studied now for 25 years in various, and the challenge is I would say this is not about whether justice courts are good or bad. I think the general feeling is justice courts do a good job. I think the question is fundamentally is some cities have indicated they want to close their courts, that organizationally, they're not organized necessarily along delivery lines. And then the question is, there are those who really want to go back to a different system and sort of come into a coalescing of that. I think the legislature is finding out now what the other task forces have gone through. It's easy to talk about, it's really hard to do. And so my feeling is I don't think you're going to see an imminent bill this session. But that's my opinion.
Thanks, Roger.
One bill we might see, it comes from Salt Lake County. They passed a resolution about a year and a half ago that during the 2025 session, they were going to ask the legislature, since their cases would go to the district courts, have to get permission from the legislature to close their court. And they had passed a resolution, the county council, to do such. I haven't seen any bill listed. I don't know if they've got a sponsor or anything like that, but that resolution as of 3 weeks ago, a month ago, when I last looked, had not been rescinded by the county. And so I imagine it'll move forward.
Thanks, Ryan.
Get my stuff.
I'm sorry, you're a lot faster moving than me, Liam. So the process of the legislature on closing courts is a fascinating one, because in truth, it goes back to, gosh, 10 or 15 years ago when the administrative office proposed the closure of one of the district courts, and they hadn't talked about it with the county that I was involved in. And there was a very nasty reaction. And as a result, you can't close or change any courts without getting a resolution passed by the legislature. So that's its derivation of that. Now, that doesn't mean that you still have to get that done, but anytime you go through a court closure of any sort, ultimately it has to be tied to a resolution passed by the legislature. So I don't know, Ryan, what's going to happen in terms of the issue from Salt Lake County. But just so you'll know, anytime you close the court from the smallest to the largest, you're going to have permission from the legislature to do that at the end. I do know, from my understanding, at least 2 to 3 city courts have already indicated they're going to close this year and have got legislation put together to do that. I don't know what's happening in Salt Lake County.
You guys could at least sit close to each other.
The exception to that is if you're closing a court and your cases go to the county justice court. So Salt Lake County currently has a justice court. South Jordan's begun that. I mean, we're deep in that process. And yeah, but if you're closing a court that your cases would then go to a state district court, the legislature needs to approve that. And so, for example, if you're in Salt Lake County and 2 years from now, they've closed their justice court, and you want to close your court, you will be going to the legislature to ask permission. Right now, you don't need to ask any permission. It closes, cases transfer, you're done.
We've had at least 3 small cities though.
So the only input I would offer, and Mark with Saratoga Springs, one of the things that we all need to consider is what's the best policy for our communities. And I realize there's the argument of we want services close to our citizenry so that they can access that. But if you go back, I would just say, since we know this is a conversation, everybody should be right now doing the math on whether it makes sense to keep your justice court open. I think last year there was a potential bill that was going to make it so that our employees would be fully governed by the judges as opposed to them falling under city policies and procedures. And I think that was kind of an ill-fated attempt to try and get something going. And they realized, wait a second, there was a huge liability on us. I think we spoke about it in last year's legislative policy. So start doing the math. We know this is coming. If you have a justice court, make sure you understand what your caseloads look like. Make sure you understand what the revenues and expenses are looking like. And that way, when the legislature asks us this question, the red can be a deciding factor of, is it a good financial business decision? If you're keeping it open for a policy because you want to have that access close to your residents, that's perfectly acceptable as well. But understand, you may be subsidizing it rather heavily, and the more cases that they take out of our courts, the less financially viable these things may become. So understand where you stand relative to it and make it a business decision that's balancing the customer service needs of your communities. And so we all have time, do the math so that if it pops up in any legislative session in the coming years, you've already come to what's best for your community conversation beforehand so that we can quickly communicate that with the legislature if it's a political issue.
Then I said, follow up on Mark's comments. This tends to hit the radar screen in the city when their term of their judges up, or when. I said this tends to hit the radar screen when the term of a judge is up. And the reason that's important is that the judge has been is in office. Even if you close your court, you have to pay that salary to the end of the term. So when I've had people say, geez, I wish I'd have thought about this before. So I would say added to that issue is factor in when your vacancies are going to arise.
Online. Okay.
So Carson, you have an online question. Knowing that you're not a data wizard up at the front and can't do a new visualization, but can the court survey be broken down by community size or county size, or do you not have enough data yet for that?
Yes, so the survey was anonymous. People had the option at the end to add their names to their response. We did require them to put the jurisdiction size, so the city or county classification. So we've looked at that. And we asked for their title, so we broke it down by whether their staff, elected official, a mayor, a council member, county commissioner, justice court staff, et cetera. And the full report has more of a breakdown there. There wasn't a lot of variation amongst the responses just based on classification alone, so I didn't include that in these slides. But if anybody's curious, I'm happy to follow up with them later. Yeah, you can just have them shoot me an email. Thanks, Cassidy. All right, I don't see any more hands. So again, please keep an eye out. We will, as soon as we give Matt a chance to kind of review the preliminary draft, we'll circulate the broader survey results so you all can see them and kind of see if there's anything else you'd like to know about it. Otherwise, we'll go ahead and move on with our other research asks. Alcohol proximity, we mentioned this at the last meeting. There's been a lot of conversation at the Capitol around economic development and how the alcohol proximity requirements and community location requirements are maybe creating some obstacles for communities who are looking to redevelop commercial areas into mixed use. So I won't spend too much time on this issue since we already made the ask, but if your community has either had anecdotes where you've tried to develop a new commercial area or convert a commercial area into mixed use and have had some challenges with the alcohol proximity requirements currently in state code, please let us know. We've asked some communities with GIS staff to put together maps, and we've asked everybody for anecdotes and received a couple of those. So again, please, if you didn't send those last time, share them with us. It really helps us better kind of understand the whole challenge and hopefully give you some more economic development tools, or at least remove some impediments in your way. And then one last thing I want to mention on research before we dive into the UEOC. The public safety survey will be fielded this week. So that's more for your public safety officers, your first responders. We're not asking municipal staff or the municipal staff or electeds to fill it out. We'll be distributing it through the public safety agencies. So through the chiefs of police, sheriffs, et cetera. So we'll just keep you posted on that, but just so you're aware, we'll be launching another survey pretty soon here. On the UEOC, this week is interim week. Today was the UEOC meeting. And Mayor Ramsey, I don't know if you have anything to add. I'll try to explain what I heard. You had 2 updates today from different industry groups. The UEOC has been kind of focusing on these target industries that the state's identified that they want to recruit more and try to develop those industries a little more in the state. Today you heard from advanced manufacturing and then also the advanced aerospace industry. And I want to mention the advanced aerospace industry specifically because they again said one of their goals is to have advanced aerial mobility, which kind of could be in the form of drones or invertiports. They want to have that in some capacity deployed in the Wasatch Front by 2034 Olympics. Now, the reason I bring that up, it still feels like the Jetsons to me, but the reason I bring that up specifically is that in some private conversations with some of the other people on their state work group, they've identified zoning around vertiports as one of the major impediments. I don't know where that's going. We haven't met with that group yet, but I just want to make you aware that zoning for vertiports and probably to a lesser extent business licensing could be a major issue this coming session. It's still too soon to tell exactly what that looks like, what their policy rationale is, what even proposals they would contemplate, but I just wanted to add that to your radar because that could start as a very small issue now and then kind of erupt when we actually see a bill with some preemptions in it. So we'll keep you posted as we know more, but just want to make you aware of that. Mayor Ramsey, is there anything else you wanted to add about the UEOC this morning? Sorry to put you on the spot.
That's okay. A couple of us in this room just came straight from there, so that's okay. Thank you. Yeah, the reason that we heard today from these targeted industries, advanced manufacturing and aerospace and defense, is because they are exactly that, targeted industries. It was a very strategic meeting today. And I mentioned to Kate as we were walking out, I said, this is the first UEOC meeting since we were created that we haven't talked in depth about certain things that always come up and about cities and whatever. And it was nice to have a conversation that was about other things and not so much directly kind of targeted at cities. It was really great because it was fantastic information. As far as the vertiport scope, they actually want them to move people who land at the airport, hop on one of these vertical teleport flying machines and be at your venue or your place within just a few minutes by 2034. There will be initial rollout of some early kind of versions of that, potentially at the LA games in 28. And by 34, Utah wants to have that perfected and really figured out. So that is a goal that we found out today is a key goal being worked on and being worked towards. Policy-wise, what that looks like, I don't know, but there was a whole layout of
Many of you, the applications you're receiving are not complete, that oftentimes they are missing information, that they have incorrect information, which takes a lot of time from your staff to review. So for a long time, we've just said, wait until it's complete and then the 14 days starts. The concern we've heard from industry is that oftentimes since there's not a defined time span between when they submit the application and when you determine it's complete, some people feel like they're in limbo for a time until they get some notification that you're reviewing it. And the code doesn't require you to do that review with any amount of time. I know some of your communities do that very quickly. Some of your communities don't do it as quickly. We've talked with the building officials trying to figure out what a realistic time to just determine if an application is complete would be. And we've kind of come back with about 5 business days. I know some of your communities could probably do it more quickly. Some of your communities, that will be a stretch. And I know that even within some municipalities, your planners will just do a very narrow check. Sometimes your planners will go through and make sure that the information is basically like the completeness review might actually be substantively similar to the actual plan review. So that's been kind of a challenge, but in an effort to just come up with more consistency and more predictability for everybody, we are contemplating reviewing or having a 5-day shot clock to review for completeness before that 14 days even starts. And then the second piece of this is if you're getting applications that are continuously incomplete, or if there's some erroneous information, that there would be an additional, like if they have to resubmit, that there'd be an additional time. We started looking at fees as a way to navigate this, but many of your communities said you weren't really interested in applying additional fees on subsequent applications, just because it might be a small builder or they could just be harder to track. So what we suggested is for reapplications having an additional time. I'll stop there. Actually, yeah, so this would be the initial completeness. This is what code currently has as constituting completeness, so an application has to meet all of these. I'll stop there really quick. On that initial concept of 5 days before the 14 days, again, this will be in the survey, but are there any initial thoughts that you'd like to share with us? Just off the cuff? Good, bad, hate it, love it? Everybody's confused, maybe? Like it, okay. Awesome. Not awesome. I heard.
Any discussion about taking it out of the Fiscal Procedures Act?
The question was, any discussion on taking it out of the Fiscal Procedures Act? I agree that does not make, that is a completely nonsensical place for it to be. Actually, that bill ended up in weird different sections of code that nobody can quite understand, but that has not been part of the conversation to date, but I assume that any changes would move it over to LUDMA where it would be read by more people, or at least the people who are looking at the requirements. Cassidy, are there any comments online? Excellent. Oh, let me get a mark really quick and then I'll come back. I'll answer that, then go to you, Mark. So the question is there data on how much of a problem this is? I don't know. When we've asked communities about their review times, and we've consistently found those within the 14-day parameters. We did not ask specifically about how long it takes to determine completeness. So I admittedly don't know. That'll probably be a question on our big fall land use survey. So we'll hope to find that out at some point. We've been approaching it for more. It's just it's ambiguous in code and it's leading to a lot of different interpretations right now.
So I just want to be clear to get our minds around it. It's for 1 to 2 unit building permits.
Yeah.
It does not include plan reviews for like site plans or anything like that relative to like large subdivisions or anything like that.
No, it should just be for, I forget the definition of construction project, but it should just be single 2-family dwellings and townhomes.
Okay. And then each of those applications is their own application, or say, let's say we get, 4 or 5 from the same builder the same day. We have the same shot clock for each of those individual unit applications.
Yeah, I believe it would be each of those applications.
Okay.
And I know you deal with more of these than almost anybody in the state right now. So yeah, we'd love to hear additional feedback, Mark. I know you guys are pretty close on track.
We're averaging 5.4 days per application. So I don't see that as a big issue, relatively speaking.
Okay.
But again, I just want to make sure, because part of the concern when they drafted this was this meaning like a subdivision of 1,500 homes and we had 14 days. And so I like the narrowing of the focus. I think if this is only for a one single or duplex home, I think that's pretty easy for a lot of people to hit. The small departments that contract this out, because there are some small cities and towns that completely contract this out.
Yeah.
It's completely dependent upon what their subcontractor is going to look like. But I think you're making reasonable suggestions for us.
Thank you, Mark. Oh, more online.
You have a comment from Dennis Marker, which says community standards for site plans or construction drawings can vary widely. A little concerned that this list is going to balloon with specifics for each of them.
Yeah, that's sort of the trade-off, is more objectivity does sort of force communities to have more collaborative approaches. Yeah, that's good feedback. Thank you. All right. The next clarification in the plan review space is clarifying that the 14 and 21 day shot clocks applied to the total plan review process. I know there's some communities, particularly those who have contracts with special service districts, provide oftentimes those will be to other entities for the Total, it doesn't get to, you don't get to the shop clock when it's going to other departments or when it's going to other entities. I think this is how many cities operate. That's kind of my understanding, but I would love to hear additional. Feedback on that. Yeah. Yeah, so these are just, unless, yeah, so these are just construction projects, so it's not the whole subdivision process, yeah. So I guess the one exception, that's probably most of the time, the one exception would be if your jurisdiction has a like dual process to modify the zoning while you're doing the approving plans. I don't think very many jurisdictions do that, but yeah, it would basically be, this is just the construction plan.
That would be land use.
Yeah.
That would be the plat adoption process. This right here should only pertain to entitled lots.
Yeah.
You drop an application for an entitled lot that is capable of getting a building permit.
Yeah, so this wouldn't be the land use application. This would just be the building permit. And my understanding is that there's not been any talks of changing the subdivision timeline, Todd. Okay, cool. So yeah, this would be focused on that piece. Any concerns on that clarification? Again, I think this probably will not affect most of you, but. All right. Next on the second kind of big land use item is building inspections, which I know is everybody's favorite subject by now. There was this year, I mean, there's the usual concerns from the Home Builders Association about building inspections being done in a timely manner. We don't believe that to be a wide problem, but the Office of Professional Licensing was requested to do a review. They do an annual review every year of certain industries, and they're supposed to cycle through industries every so often. This year, they were assigned, looking at Justin, as estheticians, massage therapists, and building inspectors, which is an interesting agglomeration. But the Office of Professional Licensing, their sort of goal is to just do a holistic review of the state's licensing for all these different professions. So with building officials, we sat down with them several times. They met with your building officials, they met with a number of cities, with the Home Builders Association, other stakeholders, just to try to understand the whole situation. And they did identify the problem of variability in code enforcement. We provided them with our numbers. They talked with a number of other entities, and I think generally found that cities are meeting the required timelines, like we've said repeatedly. But they have had some recommendations for inspections. They're sort of, I think they've been looking at this more of the sort of as a labor availability point. And that's something we heard from a lot of you is it's really hard to hire building officials right now. There's just not a lot. Some of you have gone back to the trades where they're probably making more money right now as a contractor. So their findings were that cities are meeting the timelines, but they acknowledge that cities are sometimes having a hard time just because there's a shortage of availability. Home builders have expressed frustration with the entire process, variability, and then a lack of process to appeal. And, in our usual meetings with the home builders, we've said we want to work together to solve problems, but we don't see timeliness as a problem. So we think that there's some room to try to create an appeal process that works for everybody so that we stop having quite as many issues on this, but that also respects the role of local government. So this is another one of their slides. I'm not going to go too much into that. So this is sort of the concept that we wanted to discuss. This is a dispute resolution process. There's been a few different models that have been discussed, even since last session when we had SB 185. This process, rather than being an internal city process, basically cities and home builders would create a pool of approved local government inspectors. So everybody gets together, says, these are the inspectors that both sides really like and trust, feel like they do a thorough job. And then if there's a building code issue, the builders could challenge the ruling from the building official by engaging 3 inspectors from the pool. So they get to pick 2 from the approved pool. Again, these are consensus names. And then the city picks 1. There'd be a conference call or some kind of call within 3 days for that little panel of building officials to talk through the issue with both sides, and then they would issue a ruling. The decision would be based on whether the original building official's interpretation was arbitrary or capricious. And then their decision would be binding. The reason that we're looking at this mechanism is that we want something that building officials right now are the final determiner of code, final interpreter of code for their cities. And we want to respect that mechanism. We want to keep that as much as possible. But we do recognize that there is some inconsistency in how building officials are reading things. We've heard a lot from home builders where a building official says, you know, we don't think this is code compliant or it's different than our reading, and they'll meet with other building officials who disagree. So we're just trying to figure out some kind of process that you still have local government oversight, but hopefully can resolve some of those hyper-technical building code issues that many of us who aren't building officials or in the trades don't really understand all that well. I know that was a lot. Are there any kind of thoughts on this mechanism as opposed to some of the previous mechanisms that we've discussed?
You have a question online, Carson. Is the pool picked each time a dispute comes up, or is there a pool that is picked early on and acts as the pool for most disputes in the state?
Great question. The idea is that the pool would be kind of set up in whichever year legislation were to pass. So the pool would be created. I don't know who would host the list of names, but the pool would be created, and then there'd be the panels that are picked from the pool. So anytime there's a dispute, the home builder could say, or it might even be the building official, they could say, we want to pick these people from this list to try to help us navigate this issue. It could be more regional. So if you have a building code dispute in southern Utah or Summit County where you have some kind of unique building issues, it might make more sense to do that, but it would give kind of the flexibility to do it on a case-by-case basis.
It seems to me that in the UBC, there's already a process for a dispute that we have adopted in the state of Utah. It doesn't have a timeline on it, so I like the idea of the timeline. But if there's already a process in place, do we need to change the process?
Yeah, so that's a great point, Mayor. We've brought that mechanism up a few times. What we've heard is that takes a long time, like multiple weeks, for that group to meet and discuss concepts. We've also heard that oftentimes the issues brought to the UBCC are pretty like hyper technical. It's not like a day-to-day ruling. It's like here's some really complicated part of code or some really specific issue that we need to deal with, maybe for a abnormal structure or something. You've probably had more experience with that than any of us here, but that's kind of what we've been heard, which is why we've been leading to this short appeal route. And we don't want to undermine that approach because we've heard that people like that sometimes. We just want something that builders will say that the only way they'll use it if it's really quick and has a tight turnaround.
And I agree, because timing is important, because if it didn't pass inspection, they need to meet that to pass the inspection. They can't hold the whole job off for a week or two while they get the determination made. It's got to happen within, well, like I said, 3 days. And I think sometimes stretching it going 3 days. However, as I recall, and I'd need to look up to see, but my memory is that the UBC said each local jurisdiction needs to have their own appeal process already in place. And if that's in place, then they should be able to have that work. And if that works, we just need to put the time frame into there. But I think we ought to look into that instead of creating something new, if that does exist.
Yeah. Todd, did you have anything to add on that? While Angela is moving the mic over, I'll just add one of the key provisions here, because last year we worked with the city managers to come up with an idea where basically just kind of reinforces that same concept where a city has an internal appeal process. What we heard from some managers was a concern about whether like administrators can make calls about a lot of stuff, but if it's a hyper-technical code issue, they might not have the background to be able to make that ruling. And so builders wanted to have some kind of independent technical oversight, not oversight, but like reference.
The current process creates a building board of appeals kind of an avenue. And cities generally have used the building inspectors from other cities to staff their building board of appeals. Getting groups of 5 or 7 of those folks together has been burdensome and time consuming and difficult. It took me 3 months to convene a building board of appeals on an issue to abate a dangerous building in one jurisdiction. And I don't know if we're going to find that creating a pool and scheduling from a pool is much quicker. Maybe it would be. But the current process is time consuming and hard, and I haven't been able to work around the time consuming part of it. What I think we're also finding is that if I were to ask people in this room, do you have your building board of appeals staffed? And could you convene it in the next month? I'd be willing to bet most of our cities don't have one staffed right now.
Yeah, and that's an excellent point, Todd. Part of the reason we've been looking at this mechanism is based on discussions from code officials who think that 3 days would be feasible. A lot of them think they would be able to do it sooner, especially if it's along the Wasatch Front or there's other cities nearby. But they think that 3 days is a reasonable time to meet, and they think they can resolve a lot of these disputes. To their credit, they've been really proactive in trying to figure out how to bridge this divide. And again, we'll be Norm.
Yep.
Oh, sorry.
You have one
Question
online as
I
well.
jumped the queue.
Okay, what authority does this panel have in enforcing their decision?
I don't think we've gotten to that point yet. We're really focused on concepts for all of these, particularly the housing ones. I know there would be a lot of details we work through, but we just want to see if there's room for, or kind of buy-in for this sort of high-level mechanism. The current idea is that the decision would be binding. We haven't worked through any like subsequent appeals or if you could go anywhere else. I don't imagine that they would have anything other than that legal binding decision authority. I don't think they'd be able to like issue fines or anything to a city. I don't imagine we'd be comfortable with that. And the other thing I want to mention, this isn't on the slide, but I think an important piece of this is also having some mechanism to track these and log them. Because one thing we did hear from the city managers was we want to know if our staff are the one causing problems or if our staff are doing an excellent job on the flip side. So we think having some data collection here could show us like, is it one building official who's causing a lot of frustration for builders? Or is it everybody's just having an issue with this one part of code? And that can help us better resolve problems down the line too.
So a couple things. I agree with Todd. I'm not sure this is going to solve anything. I appreciate you going through it, and I appreciate trying to put something together that we can bring back to the table. But I've heard from a certain individual from the Home Builders Association that they're gunning for this year. Like firsthand, I'm not. This is third hand, and this isn't the issue that they're gunning for. What they're gunning for is they want competition in a regulated field, which I absolutely disagree with. I think that's fundamentally flawed.
Yep.
And so they're going to keep coming. And like we see with other items and other things that the legislature keeps trying to tweak, they'll just pivot to something else. And this is the other thing that they're going to pivot to, is that we want competition. And again, I disagree with that. I don't believe that that's not a good approach when we're talking about the safety of the public.
I'm just gonna jump on that really quick. So we didn't show all of the slides from the presentation. One of the interesting things from OPLR, which is different than DOPL, by the way. So just about the Office of Professional Licensure Review started about a couple of years ago, and their job is basically to find out ways they can deregulate things. So their entire approach on this to start with was, could we get rid of the licensing requirement for building inspectors and put it on the building officials? That was like the crux of what they were looking for. And not spending a lot of time on that one, that's a different discussion. They're not really going to go down that road as far as delicensing building inspectors. But to this point about what the home builders are shooting for, they also came back and said multiple things that we didn't share here in interest of time. But one was they actually think that not deregulating is the way to go. They don't think it makes sense to go to the competitive model and having third-party licensing or third-party inspectors, excuse me, the way home builders want. So that agency came out and said, the way we're doing it right now is a good balance. They said also it would be deleterious to public safety if we didn't do this. So I know that's what the home builders want. But the interesting thing is we had this state agency get up and say the way we're doing it right now is a good way. So I don't think the home builders have a lot to rely on after this presentation for that road.
Right. I concur with you and I agree with the state, but I heard it from a
Oh, yeah.
certain individual's mouth.
he said
That's
they're-
what they're going to go. Yeah, you're correct.
I know exactly what, and
Yeah, I heard it from his mouth.
they will never not go for this one.
Right.
Because they have no incentive not to go for it. They will every year.
And part of the reason for trying to put together a proposal that I know like probably won't solve every problem, but if we can bring something proactively, we might be able to hit off a proposal we like a lot less. And hopefully this can also fix some problems on our side or try to resolve some of these disputes just so there's less pressure on those kind of proposals. All right, yeah, let's move on to bonding. All right, so first I just kind of want to recap. There's been a lot of conversations at the Land Use Task Force about bonding generally, specifically on surety bonds. Surety bonds tie up less cash for builders, basically, so they're really interested in trying to use these more. We've had a long time opposition to those being a required tool in Utah because they're very difficult to collect on. And you typically have to sue to collect on them. I'm looking at Todd. Because I've heard that point several times. So that's kind of been where we've had an impasse. There's been some conversations lately. We asked we asked the municipal attorneys how comfortable they would be with allowing surety bonds so long as a certain percentage of the development is affordable, owner occupied, and deed restricted for housing. And the majority of them said that was kind of that somewhat comfortable space. That's not a ringing endorsement, but that kind of gave us some room to look at this model a little bit more. So what we've been discussing is saying that builders can use surety bonds in your jurisdiction for public improvements if the developer or builder commits in writing to offer for sale no fewer than 60% of the total units within the project for less than or equal to $450,000. Again, this is conceptual. Don't get stuck on those numbers because those are things we'll continue to kind of dial in on. But at a conceptual level, this ties into HB 572. We've been using 450 as kind of that. It is a little bit arbitrary, but it's also a number we have in state code. So we've been tying a lot of our concepts to that for now. These homes would have to be deed restricted and owner occupied for a certain number of years. And then the owner must occupy the home within 60 days of purchasing the property. So what we're trying to do is say surety bonds are more difficult and costly for a city to navigate. So if you want to do them, you have to be tied to some public outcome that we're all trying to get to. That is affordable owner occupiable housing. So that's kind of the trade-off we've discussed. Are there any thoughts on that trade-off? Is that something we're willing to look at? Mark?
Carson. No. We have hundreds and hundreds of bonds in place at any given moment. Todd raised his hand, I raised my hand at the difficulty in collecting on surety bonds. 2008, 2009, Todd was our attorney representing on us. We had many, many instances where it was impossible to collect. And then you had infrastructure that was only partially built. And we're talking millions of dollars worth of problems associated with these types of things. It is a problem. It is not a good insurance tool, especially in a community, any high growth community. You should be terrified of what this looks like because they are very, very difficult, very timely, and very costly to try and collect on. So that 58%, they don't have to deal with them, or they haven't dealt with them because they don't understand that it is a very, very difficult process. So I would strongly encourage all of you to go back, change your Slido votes because it is a terrible, terrible idea. Thanks.
Norm?
So Mark and Carson, I'm wondering, are we talking about cash bonds then? Is that the only bond that you take as a cash bond and will developers, I'm asking you this and Mark, what is your stance? So that the only other option that I see is an escrow or some type of a cash bond.
We've got thousands and thousands of units under development that this works on. They're trying to go with a cheaper option, but it is a much more painful process. The other thing that's really important with this is if you're doing it in your community, you want to encourage developers to build as much of the infrastructure as they can before they record the plats, so they don't have to bond. Then once the plats are fully ready, all the infrastructure is in place, then they turn around and they record their plat, and then they're only doing a 10% warranty bond on that work. So we have better ways of doing this, and that is great. Give them the construction sign off, let them go out there and begin doing this. And then they're bonding for far less. To make them put a cash bond down and to build it, that's double dipping. That's not fair. But you certainly can work with them so that they hold on to their cash, they put that into the infrastructure, and then they're only doing bonds towards the end of their project when you're talking warranty issues and other things. So let's be smart and work with the developers in different ways. But for us, this is a huge nightmare. I think I have two or three full-time employees that one of their main things is just dealing with all the bonding that's happening in our community. And surety bonds, if they go bad, they go really wrong, and you end up, I think it was like a 5-year lawsuit that we were with Todd trying to get some of these things resolved. And even then, the inflation had gone up that we still ended up taking a bloodbath on it. So be very careful.
All right. Let's do one more question, and then we have one more question on bonds. And again, I'll add, you'll be getting a survey about this. Please tell us how you feel about these proposals, all of the above.
So we have some comments echoing opposition to surety bonds and difficulty in tracking. Seth Perrin said surety bonds have their challenges, and maybe those challenges are worth it for getting affordable ownership outcomes. However, maybe instead, could we find a way to make surety bonds easier for us to use or collect? As long as they are difficult to collect on, they don't feel worth it. Can the legislature make them easier to use?
Yes, and that's a great point. I know Jared Tingey on our staff has been looking into that. There's been some conversations about trying to retool how they're collected on to make it easier. I don't know where those conversations are at right now, but that's being examined as well. All right, the next bonding topic is partial release. This is another one, Mark, that you're not probably psyched on. But partial release, basically there's already a requirement in state code for you to release bonds partially as things are completed, but the way that's done varies widely, even within projects. So again, we asked UMAA how comfortable they would be with financial assurances being released with each portion of a functional system when it was completed and approved in a specific phase of development. So doing it kind of by phase rather than by piece. I see we already have a hand.
You said we're against it. We actually do this all the time. So we're all for this. This is the give and take. So we actually do this throughout all the projects. So
is there a specific way that you guys do it? Do you do it by project or do you do it by like partial completion of a project?
Partial completion. So they can submit, and just as they go along, we release the bond as they go.
And you do want to have some bumper rails in place, so you're not reducing a bond every day. But I mean, you can work with the developers and come up with a reasonable process so that you're releasing those bonds as it's appropriate. Once they get it signed off, checked, once they meet all of the expectations for it to come off of or go on to warranty bonding and stuff, it's an absolutely acceptable way. And again, it's the give and take of how we make this work. We're in a partnership with developers, and if we're treating it so adversarial that there's no give and take, then we're blowing it. But we also don't want to give away the farm. So this is one we're comfortable with.
All right. Cool. And look out for more specifics on this, because I think there's still some ongoing conversations about the exact way that you do those releases, because I know there's not a lot of uniformity amongst cities. Again, any other comments, please put them on the survey. You'll have the option to fill that out, and we want to hear from each and every one of you on all of these concepts. Which brings us to housing, and Cam arrived at a perfect time. I'll turn it over to him. And again, housing proposals will be on the survey too. So feel free to share your thoughts in here, but we really want your in-depth thoughts on that survey.
Perfect. Thank you, Carson. And good afternoon, everybody. I started my morning in Price and just got back, well, yeah, literally 3 minutes ago. And I walked in, I was down there presenting with Steve Waldrop, carpooled down with Steve. So we've had the last few hours going through a whole bunch of different concepts and proposals with Steve, and then we were presenting at Congressman Curtis's event that ended up starting later than anticipated, which is why I was late getting here. But thank you to the team for the good work thus far. Okay, as Carson mentioned, we'll have a survey going out rather than trying to do it all in person. Right, Carson, I'm confirming. Yep, I'll be going out right after this meeting, and stop me if you've already mentioned this, but we've got meetings tomorrow and Wednesday with several key legislators in the housing and land use space. And then we have our meeting on Thursday with the Property Rights Coalition. And so we're presenting all of the different ideas that are out there right now. We'll be asking for your feedback via that survey. So when we're sitting down with those legislators in the next couple of days, we've got as much of your feedback as possible. We wanted to start with these headlines because these are all headlines in just the last couple of weeks. So not the last few months or the last few years, just the last couple of weeks. And I mentioned I've spent all day today with Steve Waldrop, and I made sure that he had seen both of those headlines because the data that KUTV released or reported on September 5th about Utah building more homes than any other state in the nation, they listed the top 15 and the bottom 15. And California was not in the top 15 of housing being produced. And that doesn't take into account all the entitled units. So again, I think it fits into part of the narrative we've been pushing for a while now, that we don't need California style policy approaches in Utah because we're doing a lot of good things in Utah. We have a good story to tell. And now it's how do we solve some of the problems that are still out there? What's also been fascinating in just the last few weeks, these again are all September headlines, is both presidential candidates have announced plans around housing affordability. And one of the centerpieces that they have both put in their plans has been to deregulate local government. So I was on a call last week with leadership of the National League of Cities and pushing National League of Cities to be using their contacts within both presidential campaigns to understand like what exactly is it that the two campaigns are trying to accomplish here by attacking local land use. And then Jerusalem Demzis was actually in Utah last year, and she just released a book, which you can see the headline at the bottom right here, Who's Responsible for the Housing Crisis, How Local Governments Broke America's Housing Markets. Now, again, I think the story we have to tell in Utah is much different than the story that is happening in other places around the country. But it's also just important to know that all of these are just headlines from this month about local land use being in the crosshairs around the country. Okay, so we have the Commission on Housing Affordability, and then here are some other big ticket items. We do not have legislation on any of these, but these are going to be big. I want to make sure they're on your radar because at some point we will be reaching back out to you for feedbacks. Number one, the governor has tasked Steve Waldrop with building out the Utah State Housing Plan. And again, I spent all morning with Steve today. He is in the infancy stages of the housing plan and wants to have a high-level concept to present to the legislature in January. Now, the details are still very much up in the air, and he acknowledged today he's just at the very foundation piece of this, and what are the policy pieces to it, what are the financial pieces to it, et cetera, and then how does it build on all of the stuff that we have done to date. But just know that's a big one. And if you think back to the legislative audit last winter, one of the recommendations that came out of that legislative audit was a state housing plan, and the league board expressed a willingness to have a conversation about state housing plan as long as it recognized the role of local government, respected the role of local government, and wasn't just a rationale to have a state mandate to preempt local government. And again, right now, it's still very much in its infancy. Okay, big ticket item number two. Just this week alone, there is going to be several committees looking at housing related concepts. Economic Development Interim Committee on Wednesdays looking at ADUs. Thank you to Farmington and Mill Creek and St. George City. They've all accepted the invitation to participate in that hearing. Political Subs is looking at the housing audit again on Wednesday. And then these three legislators have all opened bill files to look at investors, owned property, short-term rentals, and requirements around small lots. And then the third big ticket item, this is one that I think will be a great opportunity for us to tell our story. And Saratoga, I'm looking at you because of the tremendous data that you already have, but Envision Utah got the contract with GOEO funding to build out a land capacity study. There'll be a more formal term for it later, but the concept here is, where do we have infrastructure to support more housing? Where is the market pushing for more housing? Where do we have water constraints or water supply? And then what is the zoning in these different areas? This is a concept that came before the UEOC last summer. And last summer, we said, yeah, it would make sense to have this sort of data drive the policy discussions. So GOEO got one-time funding last session, which again, we were supportive of. Envision Utah got the contract, and now they will start building it out. They've not yet put together a technical committee. We've asked to be part of their process, and they've agreed. But again, just want to make sure this was on your radar as part of the big ticket items. Okay. Okay. So now let's talk what's before the CHA. Mark, are you putting your hand to the square? Or are you asking a question? Okay. Okay.
Utah or something, because quite honestly,
Tired of Envision Utah coming and saying, oh, it's just your NIMBYs. They don't understand. We're tired of listening to Envision Utah tell us that. I'm all for the study. I think this is wonderful. You know me, I love data. This is great. But I don't think that they can actually sit in a room and probably listen to the concerns of our constituencies without coming across as already biased. And so that would be my only comment on this. But as far as the data, all of those things are very important. But Envision Utah has been pushing their memo and their message for a long time without looking at any of the data behind water, infrastructure, and other things. So perhaps that should have been the first question asked, as opposed to the Envision Utah propaganda that then drives these decisions.
Okay, now I've got Norm as well over here. And as the microphone makes its way to Norm, we've heard a lot of those same frustrations with Envision, and I'm more than happy to share that feedback directly with them. I will note it was GOEO's money, and GOEO's already done the selection. So it is what it is at this point, but I think that those concerns are fair, and we've heard those concerns previously. Norm?
So Cam, in the number two, the two about investors and short-term rentals, are they trying to look at the detriment to the market that those are? Are they trying,
Yes.
is that the intent?
Yeah. So these aren't bad things. Like, I think these are great questions that legislators are asking. Sorry, I skimmed over it. So let me be clear about it. In the case of Representative Benyon, she's very concerned about investor-owned housing stock and the impact on the market. In Representative Walter's case, he is concerned about the proliferation of short-term rentals and its impact on housing availability. And we have our Gardner Policy Institute data that we funded. And Carson, I'm not going to put you on the spot for the exact date, but I know Carson received a draft of that research last week. So we're hopeful that in the not too distant future, we'll have updated data about the impact of short-term rentals on the housing market. And Representative Walter wants to tackle it in legislation. Both of those concepts have come up before the CHA, but these are legislators independent of the CHA who have opened bill files too. Other Todd.
Will Walter's short-term rental regulations look anything different than Benyon's short-term rental regulations for the last couple of years?
Yes. And I say that with an asterisk because I'm meeting with Representative Walter tomorrow. And part of my objective meeting with him tomorrow is to walk him through how we got to the point we are now, and then what's been suggested in years past. Within the Commission on Housing Affordability, we've brought short-term rentals up as an issue that needs to be discussed, but we've also said, let's wait until we get the Gardner data so that the data is driving the policy discussion. Okay, any other questions about this slide before I proceed? Okay. Within the CHA next meets on October 1st. So this will be the last LPC before that next CHA meeting. They are transitioning now from the concept phase to the proposal phase. So we're going to walk through some of the different proposal ideas that are out there, and we'll be surveying these later today. First, moderate income housing plans. It's no surprise that legislature wants to tweak those. And on one hand, our folks have a lot of frustration with the constantly changing nature of moderate income housing plan requirements. On the other, we also hear from our members that they're frustrated around some of the ambiguity in there. So is there a way to solve two problems at once around what is actually compliance? What does the ongoing implementation mean? And interestingly enough, if you look at all the menu items within MIHP, none of them are actually focused on ownership. So is there an opportunity, if we're going to revisit some of the MIHP menu items, to shift focus of some of them onto ownership? Okay. Our internal LPC CHA subgroup, when we asked them a few weeks ago if their cities would be very or somewhat more likely to adopt more objective MIHP actions if it came with a guarantee that you've automatically complied, 78% of them said, yeah, we'd be open to that. Okay. Interestingly, at annual, just a couple of weeks ago, which feels like a year ago now, but a couple of weeks ago at annual, only 5% of the attendees, when we asked the whole conference, said they don't allow at least one of the following: townhomes, duplex, triplex, missing middle, single family, et cetera. So the vast majority of cities are allowing a variety of housing types. Then we also asked at annual if your city would be willing to adopt an overlay in part of your city that gives more incentives in exchange for guaranteed affordable home ownership. And you can see 58% were in the supportive space, or supportive is not the right word, in the comfortable space. And then 28% were unsure and 13% said no. And a lot of this comes down to details. We're going to bring up some details here in a second. And then we asked the LPC advisory group around garages and parking if deed restricted for ownership. And you can see the numbers there on the right. Likewise, we asked the board, if you require a garage, then it has to count. And you can see strong majority said that. Okay, so you've given us those survey results. We have shared some of these survey results with Steve Waldrop and others within the CHA. And so here are some of the, we're shifting from concept to potential proposals now. So here's the proposal we want you to chew on and give us feedback on in the next day or so. The existing law under MIHP has a lot of flexibility in it for how cities come into compliance. And that's both a good thing and a challenging thing. The good thing is you choose your own adventure. The challenging piece to that is what is compliance, and compliance looks a little different depending where you are. So for example, one of the menu items relates to accessory dwelling units, and it says create or allow for and reduce regulations related to ADUs. Carson on our staff has read all of the MIHP reports. I have not. Carson has, and he shared with us the results of his analysis. So these are two cities that are both in compliance in two different approaches on ADUs, but he's gone through and kind of said, here's how all the different cities are approaching ADUs. So in one case, it was just a presentation and they're doing a survey. Another passed an ordinance to allow detached ADUs in certain areas. Both of those are in compliance, but you can see they're different ends of the spectrum. So the thought here is, do you create some sort of safe harbor where there may even be multiple safe harbors within the ADU space? So if you allow for a detached ADUs that could be sold, this is the Farmington model that is still really quite unique nationwide, not just in Utah. But if a city did the Farmington model, or if a city did large lots, certain percentage, you would know you'd automatically be in compliance. So it makes the reporting easier, but also gives you something more actionable and allows us to say to the legislature, like, we did these things and either the market's responding or it's not. So it'd be, we're framing this as safe harbor, but that would be the concept that for certain MIHP strategies, you give a little more specificity in what the strategy is. Okay, so that's the safe harbor. Now, Steve actually suggested I change that from super menu to just weighted menu item, but I didn't get a chance to tell you that before I got here. So it still says super, but this came out of a conversation with some mayors in Weber County, where we were meeting a few weeks ago, and they were asking which menu items are actually making a difference. And the response that I gave back to them is, we're still not 100% sure what's making a difference. Okay, well, if we knew which ones were making a difference, should we weight those differently than other items? Likewise, if the objective for all of us is more affordable home ownership, and right now the MIHP menu items are basically silent on ownership, should we look at creating some menu items that are focused on ownership and then weighting them differently? Okay, so that's the thought process behind this idea. So you could have a weighted strategy focused on ownership and then give a few options. And I'm going to use Far West as an example. You're never going to have an HTRZ in Far West until you get the front runner station back up and running in Pleasant View, right? So if you couldn't satisfy that through an HTRZ. But what you could do in Far West is you could look at a FIZ, and I know that you're looking at a FIZ, right? So Far West could be looking at a FIZ and saying, we want to promote ownership through a FIZ. Well, that may work in Far West because of the location of that spot, but in Santa Clara, maybe the FIZ doesn't really work in Santa Clara, but what could work is doing a HOPS or working on a project that's getting 572 funding. And I was asking Steve this morning, what in addition to the West Weber County project has applied for 572 funding? He said there are several that are in the pipeline right now. He's going to get us details of those. Likewise, he shared with me, and Mayor Staley had mentioned it previously, but that in Washington City has been working with a builder right now where the builder has some entitlements on multifamily units, but the city and the builder are working together to change the entitlement, providing additional density is what the city's offering, but in exchange, the builder is going to turn them into condos rather than apartments. So, that could be the super menu or weighted menu item is say, here's what we're doing in addition to our base zoning. Washington City's case, we're trying to incentivize condos. And then this qualifying overlay concept, I know Seth is on the call because I heard him ask the question as I walked in, but Spanish Fork recently did a really interesting overlay, and I read through it last week. And in their case, it's not tied to ownership, but it is tied to a density bonus in exchange for some of these other community benefits. Salt Lake City has an overlay that's really focused on affordability. So if a city did a qualifying overlay, that would also qualify here. So again, if the goal is around ownership and MIHP right now is not focused on ownership, do we create some tool or do we create some strategies related to the tools that have passed to focus on ownership? Okay, so I just talked a lot. What questions do you have about these concepts? Because we're going to be surveying you in the next 24 hours on them. Let's start with Mayor Ramsey, and we'll go from there.
Thank you. I have a question. Number one, adopt or propose an HTRZ. I do think that expanding the MIHP requirements to give greater consideration, now that we're a few years into it, to the things that are working the best, that makes sense to me. It does make sense. And the same with adding additional options that are focused on housing, home ownership. Big fan of that. That's a great idea. My question is about number one, adopt or propose an HTRZ. As an HTRZ city, I'm wondering, adopt or propose an HTRZ. If that only qualifies for the year that you do it, man, those are a lot of work and you're going to be administering that for a long time. I would love to see that say adopt or propose or administer an HTRZ, because that's not just a one and done thing. And I think if we're weighing these different based on what they are, then that should count for longer than 1 year.
Yeah, great point. And I think the signs to South Jordan City should say, welcome to an HTRZ city, and let people like scratch their heads. What does that mean? But you're spot on, and highlighted below is how to count existing units, because this has been one of the fundamental challenges with MIHP from the get-go, is how to take into account existing work in this space. So, not in your case, you shouldn't be penalized because you were at the front of the line on HTRZs rather than the middle of the line. So yes, amen. I think that's a great point for HTRZs and the other thoughts. Other clarifying questions here, knowing you'll have a chance to fill out the survey here later today, but other questions about either the safe harbor concept or this weighted menu, super menu concept around ownership. Anything online, Carson? Okay, I'm going to keep going. Okay. Last month, we brought you a proposal around parking in garages, and we surveyed you in the meeting, and the response was really quite split. And as a reminder, if this were a bill, our LPC bylaws require a 60% threshold for leak support, and we were not at 60% with what we brought to you last month. So we've since kind of taking it back to the drawing board. Now, the problems that PRC's highlighted in parking and garages is, I think at the core is they just want better consistency on counting. And they've given us multiple examples of where in Rogers City, they have the same house, the same plan, the same driveway length, the same everything. And Rogers City's counting it as 4 parking spots, but in Cameron City's not counting the driveways. So it's only counting as 2 spots, even though the dimensions are the same everywhere. So they're looking for some consistency there. And then, they are looking for ways to reduce the price of housing and have focused on garages. We've pushed back based on your feedback around livability and quality planning and sufficient sizing. And then we've done some research based on your input around the variety of regulations that cities have. Some base it based on type of units, some base it based on bedrooms, and that also gets to the different types of counting. So the way we are proposing to modify it would still, number one, would still be similar to what we presented last month. That single family detached unit that is affordable and owner occupied, city can't require a garage, but can still require on-site parking. So again, similar to the conversation you had as I was walking down surety bonds, if the outcome is affordable home ownership and it's guaranteed to be such, then this would be the potential trade-off. The second thing is the structurally unobstructed. I'm sure there's a better term, but this is getting to the point that the garage actually has to be big enough to be functional. So if you're requiring a garage, it actually has to be able to park a vehicle. And then talking through the definition of a size of a parking space, not for apartment buildings or anything else, but single family townhomes and covered versus exterior, and then tandem so long as affordable ownership. So this is a more narrow than what we presented last month in response to the feedback that you gave us. So that'll be in the survey as well, right? As a follow-up question there on the garage piece. Okay, this one, before I leave garages parking, we spent a lot of time last month, and again, we're tweaking it based on your feedback, but any other thoughts or questions on this space? Let's go Norm, and then Carson, let me know if there's anybody online.
So you kind of have it on here, Cam, but I think it needs to make sure that we're definitely staying on single family dwellings, right? One of the things that I've heard in our city is that our parking requirements are stringent. Well, guess what? We have no parking requirements on single family dwellings. We do on family attached. So I think we need to make sure that we're staying on distinction here and that we're making sure that what we're talking about is oranges and apples and not apples and pineapples, right? So we need to make sure that this argument, if they're using it, is being used on single family homes that are affordable, et cetera, and not some interpretation of what a different code is as a requirement on a single family home that's supposed to be affordable.
Yeah, great point. I also love the apple pineapple thing. I've never thought of that until now, but that was a great line. Yeah, but yes, you're spot on. And again, this comes back to if the objective is more single family detached owner occupied units, then are we willing to have some trade-offs for those types of units? And if so, what does that look like? Recognizing that there are a lot of Santaquins out there based on our research that are not requiring exorbitant parking or really any parking at all. The market is still doing it, but this allows us to go back and say, like, we were willing to make this trade-off and the builders weren't taking us up on it. Whereas there are some examples around the state where the cities have scaled back the parking and the developers should come back and say, okay, then we can make this work and this work and this work. And that's what we're trying to figure out. Okay, any other questions in the parking garage space? I have one more housing slide. I know the clock's running, but I just got here. I feel like I got another hour in me, but I don't think you guys do. So any other questions in the parking garage space before I hit the other CHA items? Carson, nothing online? Okay. All right. The other 2 CHA groups, well, there are technically 4 CHA groups. So I just shared with you some of the latest points in CHA subgroup 2. I should also note, and we mentioned this last time, that there still is a push within CHA subgroup 2 to just do a blanket upzone of the state of anywhere from +1 to +4 units everywhere in the state. And I keep trying to ascertain how much appetite there is at the Capitol for that sort of blanket upzone. And here's how I'm going to describe it as of September 16th at 1:44 PM. I think there are some legislators that just like that idea because feel like the blanket up zone will just make it easier to build more units solves the problem solved. I think there are more legislators who are anxious about the fights with local governments that would entail and the legitimate questions it brings around infrastructure and planning and everything else. There are some legislators who have said, well, what if the upzoning only applied to owner occupied units? Okay, so I'm going to use Saratoga as an example. Saratoga has about 30,000 entitled units that are waiting for infrastructure, waiting for permits and everything else. So if you came back and said, okay, we're going to increase residential density by 2 units in Saratoga Springs, everywhere else, all the infrastructure that they've sized for that for all those new projects, now they've got to go back and resize all that infrastructure. And then some legislature will say, well, what if those are guaranteed to be owner occupied? I think the response back from Saratoga and those other cities that have sized the infrastructure accordingly is like, that's great, they'd be owner occupied. I still only have so much water. I still only have so much pipe capacity, so much road capacity, et cetera. Okay, so that's the greenfield example. For an infill city, and I'll just use Cameron City for the infill city. There's been a lot of pushback at the Capitol in recent weeks saying, well, are the infill cities, do they have infrastructure, excess infrastructure capacity to accommodate more housing units? And then if so, is it easier just to do it statewide rather than having neighborhood by neighborhood fights? And if you avoid the neighborhood by neighborhood fights and just upzone it, does that actually reduce the power of land speculators? Because now they're not going in and upzoning one by one, you're doing it statewide in a blanket wide approach. So I'm just giving you a sense of the arguments that are going back and forth right now. And it's why we've been trying to stay laser focused on affordable home ownership and are the tools achieving that. But I just want to make sure you're aware, like that +1, +4 blanket upzone concept is still very much out there. And several states have done that sort of blanket upzoning. And I think it will forever be out there. So just be aware of that. The other CHA group that's not on the slide is Carson's group that's really doing the deeper dive into the data stuff, which will be informing the state housing plan. CHA subgroup 1 is looking at these items: public lands, removing barriers to condos, short-term rentals, incentivizing home ownership. So at the annual, we asked a couple of caucuses and we asked our advisory group to prioritize potential tools in this space. And these were the 3 that they prioritized. We gave them quite a few, and these were the 3 they prioritized. Now, I recognize what Governor Cox said on our stage, and I don't see Ken, I saw his mayor a second ago, but I don't see Ken Leatham here in person, but Ken was a soldier, man. Like he got up there, he asked the governor what hundreds of you wanted to ask and got the answer that the governor's been telling us, which is not interested in expanding that program. Last week within the CHA, I again brought this point up, and Dave Damshin and Steve Walter both say, like, we hear the concern from legacy cities. There may be other ways to do it other than that particular program. There may be other funding sources available, particularly to help renovate units and converting them from rentals to ownership. So, but I almost put us, so you're saying there's a chance, meme in here. So just, don't give up on the concept yet. Likewise, the second piece, the revolving loan fund, several cities are already doing this with federal funds. And Steve, recently, as an hour ago, was telling me he's really interested in trying to find state matching funds that could help a West Valley city or an Ogden city come up with dollars to purchase units that are currently rental units and sell them to first-time home buyers with a deed restriction to keep them in the ownership market for a while. And then the property tax piece, there may be some room and some definitions short of a constitutional amendment, but those are the 3 that the group most prioritized. Then I mentioned when I answered Norm's question earlier about kind of where things at are on the short-term rental piece. So I realize it's September 16th. We're still in the concept, but now pivoting to proposal space. Steve told me this morning on the public land piece that Commissioner Valentine's been working on a way to share some data across governmental jurisdictions. So to make it easier to do an inventory of who owns what governmental land in each community. He mentioned that several state agencies are prioritizing this year so that, for example, UDOT would do an inventory of all of their surplus land that they don't think they'll need for roads going forward, and then figure out how to potentially use some of that land for affordable housing. Because if you own land, if you don't, you could sell it, or if you kept it in public ownership, it could be used, or the actual price of the unit should be much lower because you don't have the input of the land cost. And so stay tuned. He's setting up a meeting with us and Commissioner Valentine and others to figure out this exchange of information. And when we say publicly owned land, that's everything from school district land to SIDLA land, from city-owned land to state land, all of the above. And then Lynn, because of time, I won't ask for a report, but Lynn, Mayor Silvestrini, Mayor Bruno from Springdale, and Danny Walls are on this CHA subgroup one with me. And there's been some really productive conversations in the condo space. I don't think we've cracked the code yet, but I think we're moving in the right direction there. CHA subgroup 2 also has Lynn and Mayor Silvestrini, but Mayor Palmer from Harriman and Councilmember McDonald from Orem have been great advocates in that subgroup. Okay, any final questions about where we're at wise, or any other housing or land use related questions now while we're all together that we can answer before the survey will go out? None.
So Cam, on the upzoning, the +1, +4, +65, whatever they decide. is the best.
+65.
I think it's important, like you have with the California example, is to point out those states that have already done that. Point out that they've already solved all the affordable housing crisis, right? They're good. Am I understanding that right? I think that needs to be pointed out. So just because other states have done it doesn't mean it's working. It doesn't mean it's best for us.
Yeah, amen. And in my conversation with Steve this morning, he's in the national conference later this week, and he plans to say, like, here are the things we're doing in Utah that I think make a lot of sense. And he's going to try to learn what other states have as suggestions that aren't California. Because it's easy to tell that, well, yeah, let's do this, but yeah, California does not have a track record of success, with one potential exception. And I say potential exception because the data is still fairly new, but several years ago, the California Assembly preempted cities in the ADU space entirely. And in the last couple of years, you're starting to see a growth in ADUs that is ahead of the historic trend. So whether that's causation or not, it's still early, but that would be the one data point I think you could look at and say, okay, maybe it's having more affordability and more ownership. Not yet. Yeah. Any other questions in the housing land use space? Okay, before I cede the floor back to Justin, Provo City, I don't see anybody from Provo in the room, but Provo City is hosting the Housing Summit with their legislators on October 10th. On October 10th and 11th, the APA Utah chapter is having their conference in Provo. Highly recommend that if you can, that your parents attend that. Evening of the October 10th for a reason. Steve Waldrop asked me, because he's going to go to that Provo meeting, as am I. He said, while I'm in Provo, it'd be great to meet with other cities in Utah County earlier that day. So those of you from Utah County who are in the room, I invite you to stay after for just a couple minutes we could quickly brainstorm how could we build out a worthwhile and productive day for Steve earlier in the day on October 10th. For those of you who are online, just shoot me a text if you're interested, and we can help build out a day leading up to that Provo housing event on the evening of October 10th. With that, Justin, I think that's everything I have. So thanks everybody for your participation today.
All right, a couple quick things, and this will be about as long as it takes Kate to walk up here to adjourn the meeting, but she's talking, Mark, and not listening. One, we're updating our website. As much as we love the stock photos, and I do love some of the stock photos, they're phenomenal. We're pictures from your city. So if you have pictures from your city, send them to us. We'd like to put them on the website. Highlight a lot of the cities in the state. The other quick thing I need is, if you are interested in beekeeping, and now I know I got all of your attention, there was a bill run last legislative session that says Department of Agriculture and Food is updating rules around beekeeping across the state, and we do need a representative from the cities on that one. So if you're interested in talking about the rules around beekeeping, let me know. Some of you laugh, but there is someone out there who is listening, who is excited. And you can help make the beekeeping rules across state. And with that, Councilmember Bradshaw, to you.
It is my favorite part of the meeting.
I know
I
it
am
is.
looking for a final motion.
Motion to adjourn.
Oh, thank you, my colleague Richard from Bountiful. Oh, and a second from Norm. All in favor, please say aye. Any opposed? Looks like we can go home, Justin.
Sounds good. Thank you all.